Now, Adam Rooney will examine the Supreme Court case of Atkins versus Virginia.
Hi, I'm Adam Rooney, and I'm here to examine the Supreme Court case of Atkins versus Virginia. Now, mental retardation is a very serious issue in today's society. But have you ever considered that this human disadvantage could possibly save your life? That was essentially the case during the Atkins versus Virginia trial. Take a look.
August 16, 1996, Dale Atkins and his friend William Jones abducted Eric Nisbet, an airman from Langley Air Force Base, from a nearby convenience store. They then took the $60 from his wallet and forced him to withdraw $200 more from a nearby ATM. After they had the money, Atkins and his accomplice drove off into an isolated area and shot Nisbet 8 times. Evidence of this crime led to the immediate arrest of Atkins and Jones, and through vast questioning, it was decided that Atkins pulled the trigger. During the penalty phase of the trial, the defense presented Atkins' school records and the result of an IQ test, which he scored a 59 on. An IQ of 59 is technically mentally retarded, but Atkins was still sentenced to death by the York County, Virginia Circuit Court. The sentencing was appealed and brought to the Virginia Supreme Court. The Virginia Supreme Court affirmed the conviction, but forced the case to be re-examined by the York County Court. The York County Court upheld the death sentence, and Atkins was then put on death row. Claiming that state legislature regarding the execution of the mentally retarded has changed, the Supreme Court decided to review the case. The first aspect of the majority opinion was looking at the previous cases similar to this one. The court had previously found that the death penalty was inappropriate for the crime of rape in Cooker v. Georgia, for example. The court then described how a national consensus that the mentally retarded should not be executed had arose. In 1986, Georgia was the first state to allow the execution of the mentally retarded. The next year, Maryland joined, and over the next 12 years, 19 more states exempted the mentally retarded from capital punishment under their laws, bringing the total number of states to 21. The court claimed that executing the mentally retarded is a cruel and unusual punishment, which are forbidden by the Eighth Amendment. The Eighth Amendment states, "Excessive bail shall not be required, nor excessive fines imposed, nor cruel and unusual punishments inflicted." Although they can know the difference between right and wrong, these deficiencies mean that the mentally retarded have a lesser ability to learn from their experiences, engage in local reasoning, and understand the reactions of others. This means that inflicting the death penalty on one mentally retarded individual is less likely to deter other mentally retarded individuals from committing such crimes. In dissent, Justices Antonin Scalia, Clarence Thomas, and Chief Justice William Rehnquist contended that despite the increased number of states which had forbidden the execution of the mentally retarded, there was no clear national consensus. They also argued that technically there was no basis in the Eighth Amendment for choosing such measures of opinion to determine what is cruel and unusual punishment. Despite the opinion of the dissent, Dale Atkins had been exempted from the death penalty.
Hi, I'm sitting here with City Council member of Seattle, Bruce Harrell. How are you doing today, Mr. Harrell?
I'm doing well, thanks for asking.
Okay, so now we're going to discuss and further elaborate on the Atkins versus Virginia trial. So he's very aware of what took place during the trial, but I have a few questions to ask him. First of all, the determining factor during this trial was the IQ test Daryl Atkins took. That qualified him as being mentally challenged. Do you think that a failed IQ test should determine if one is mentally retarded?
No, I don't think that an IQ test in and of itself should be the determining factor. I think that testimony from a professional psychiatrist or a psychologist, perhaps applied behavioral scientist, people along those lines, should give a very in-depth analysis to determine whether a person is in fact mentally disabled or not.
Okay, so essentially what you're saying is the way somebody lives their life and the way they interact with other people should determine if they're mentally retarded, not just a standardized test.
Yes, I don't believe that a test in and of itself is the deciding factor.
Okay, that's valuable. Next, well, Daryl Atkins scored a 59 on his IQ test, which did qualify him as being mentally retarded. Do you think that those who score this type of score on the IQ test and qualify as being mentally retarded should be eligible for the death penalty if they are tried for murder?
No, and let me elaborate if I may. Okay. That a failed IQ test or that kind of test coupled with scientific evidence, again from a psychiatrist or psychologist, if after that kind of analysis a person is rendered mentally incapable of committing a crime, or mentally retarded, if you will, then I don't think that they should be subject to the same kind of death sentence or punishment as a person like you or myself, Mr. Rooney. You know, at the end of the day, we're trying to find justice. Our courts are alive and well to seek justice. One has defined justice as to treat equals equally and unequals unequally, in proportion to their inequality. And by that I mean that a person that is mentally handicapped is not equal to you and I. They're not capable of thinking the way we are. And so our law needs to be flexible to understand that they make decisions differently. Now, even though they make decisions differently, I do believe that they are capable of committing some kind of crimes and should basically still be subject to our laws. They shouldn't be able to get away with murder or committing crimes without any recourse at all. You know, in order to commit a crime, it does require some level of intent. That means being aware of the situation around you and intending to do harm, intending to take something. And that's contrasted with a person that doesn't realize the consequences of their action. So even though a person may be mentally disabled, perhaps they still have an appreciation for the repercussions of their act. And if that's the case, then certainly they still should be subject to the laws, but not with respect to the death penalty. I don't believe that that makes sense at all.
Okay. Thank you for your time, Mr. Harrell. Ladies and gentlemen, we've heard a very valuable opinion in City Council Member Bruce Harrell's thoughts regarding the death penalty qualifying for those who are mentally retarded. Thank you for your participation in this interview today, Mr. Harrell, and I'll let you get on with your day.
Thank you, Mr. Rooney.
Now you're probably wondering how I feel about this case. I think that Daryl Atkins should have received the death penalty. Earlier that day, Daryl Atkins and his friend William Jones had been smoking weed and drinking alcohol all that day. Daryl Atkins had been living his life as a free individual, creating his own thoughts, making his own decisions, and having his own tasks. Of these tasks was to steal $200+ from a man and kill him by shooting him 8 times. I think I agree with the Supreme Court's decision to ban the death penalty from those who are mentally retarded, but I do not think Daryl Atkins qualified, and he should have been eligible for the death penalty, at least. But anyways, thank you for tuning into my section of 60 Minutes, and I hope you have a wonderful week.